Hello, good day everyone. This video will discuss about damages for delays to completion. The video presentation is subdivided into the following: a short introduction about the topic, forms of damages, how to demonstrate a claim for damages, the methods of calculation and application of damages, and the last part will cover what to do if there is an incorrect application of damages. This video presentation was prepared in reference to RICS Guidance Note, first edition, on damages for delays to completion. As we all know, the construction contracts have start and completion dates. Most contracts have a provision that when the contractor fails to complete the contract within the scheduled completion date, the contract will be liable for damages. Damages, in simple term, refer to a form of compensation due to a breach, a loss, or injury. The general principle of damages is to return the non-defaulting party to the position they would have been in had the contract has been performed without the breach. And the amount of damages intends to restore the injured party to the economic position they had expected from the performance of the contract. Generally, damages has two forms: the unliquidated and the liquidated. The unliquidated damages are based on the actual loss of the employer, and the amount needs to be proven at the time of loss. It is not necessary to agree the level of damages at the beginning of the contract because usually there is no value entered in the contract. Where unliquidated damages are applicable, the parties may be subject to lengthy calculation and agreement. However, the advantage of unliquidated damages is that it allows for recovery of losses that may be impossible to foresee or to estimate with any certainty at the beginning of the contract when there was still no breach happened. On the other hand, liquidated damages are the amount of money agreed upon by the parties at the time of the contract signing. The amount establishes the damages that can be recovered in the event that a party breaches the contract when the delay is beyond the completion date. The amount is supposed to reflect the best estimate of actual damages at the time of signing of the contract. One of the advantages of liquidated damages is that there is no need to prove the actual loss, since the contract loss already provides the pre-estimated amount of damages to be paid by the contractor. The predetermined sum allows the contractor to be aware of their liability if they will become late from the scheduled time for completion. Therefore, they will be able to budget for the risk of delay and adjust their tender accordingly. This will also confirm the remedy available to the client or to the employer in the event of delay and also provide certainty to both parties. Therefore, liquidated damages may be more preferable by both contractors and employers than the unliquidated damages. According to the principles of the law of contract, to succeed in a claim, the claimant would need to demonstrate the following. First is the breach of contract caused losses in the amount claimed. The breach of contract is a necessary prerequisite for claiming damages. Therefore, when preparing the claim, it is worth mentioning the specific loss that has been breached. There must be a causal link between the breach committed and the loss suffered for a claim of damages and the attaching liability. Second is the loss was not too remote at the time of formation of the contract. The term remoteness refers to the legal test of causation, which is used when determining the types of loss caused by a breach of contract or duty, which may be compensated by an award of damages. Legal causation is different from factual causation, which raises the question whether the damage was resulted from the breach of contract or duty. Accordingly, once the factual causation is established, it is necessary to ask whether the law is prepared to attribute the damage to the particular breach, notwithstanding the factual connection. Damage which is too remote is not recoverable, even if there is a factual link between the breach of contract or the duty and the loss. A party claiming damages on breach of contract ought to have performed or was ready to perform the required part of the contract. Hence, the duty to mitigate losses is indispensable before claiming damages. So the claimant must be able to establish a reasonable steps to mitigate the loss. It is a key factor of liquidated damages that the amount must be a genuine pre-estimate of the loss. The calculation of the stipulated sum in the contract is very important because the court may deem the damages as a penalty if it appears to be deterrent rather than a compensation to the non-defaulting party. The amounts construed as a penalty will be unenforceable. Therefore, it is recommended that calculations for liquidated damages must be thoroughly considered, and a detailed record of the final value must be retained in the case the amounts are challenged at a later date. Damages can be calculated in a number of ways depending on the nature of the project. So, for example, in a construction of a hotel, delay damages can be calculated from the loss of revenue from the rooms and the loss of revenue from other facilities, such as restaurants, events rooms, and the leisure facilities. There are matters such as occupancy levels, likely room charges rates, income from restaurants and leisure facilities of the hotel, as well as costs that may be saved as a result of delay, such as utility consumptions, the water, electricity, and, for example, also the telephone bills. This list by no means is exhaustive. And we must note that calculation cannot be based purely on the revenue. For the construction of an office block, liquidated damages may be calculated from the cost of leasing an alternative accommodation if the occupant is the owner of the project. However, if the office building is likely to be leased out, the damages would be calculated on the likely lease incomes, which is similar to the calculation of the example for the hotel in the previous slide. There are other cost items for consideration, and this includes continuing construction supervision cost and fees, accommodation cost, and finance cost. This list is, of course, deemed not to be exhaustive. It is more difficult to calculate the amount of damages for civil engineering projects such as roads and sewer treatment facilities. It may be difficult to put a financial value on the loss incurred from not having a road upgrade available. It is more likely to be a matter of bad publicity for the road owner or developer. It may also be more difficult to calculate the level of damages to apply within a subcontract. Therefore, the contractor will need to consider if the subcontractor being late will have an impact on the other trades and or have an impact on the overall completion of the project. The damages may become disproportionate to the value of the works covered by the subcontract. Contractors may therefore choose to enter into subcontracts with unliquidated damages. Different contracts deal with the application of damages in different ways. In some instances, this is included within the completion certificate. However, other contracts deal with this by issuing a withholding notice from the employer or the client after the aforementioned certificate has been issued. In some contracts, it may be a condition precedent that prior to the deduction of delayed damages from monies due to notices are issued in accordance with the contract requirements such as non-completion certificates. Some contracts also has a limit on the contractor's liability for damages, and this should also be taken into consideration when administrating the procedures for recovery of damages. There are cases where an extension of time is awarded late in a contract, that is after the late completion of the works, or let's say a section by the contractor. If the damages were previously applied, then the level of damages deducted must be reassessed at the assessment of next interim payment application. Interest may also become due on the amount of damages that were incorrectly taken, but this will depend on the provisions contained within the contract. This ends this video presentation, so see you again next time.